Welcome back to the podcast where we break down the legal funding world and give you the tools and insight you need to make confident decisions while pursuing justice. Today, we're tackling a question that's more common than you might think. What happens when the person you're suing, or the person suing you, doesn't have the money to pay? Whether you're the plaintiff trying to recover damages or the defendant trying to avoid financial ruin, the legal process doesn't pause just because money is tight. In this episode, we're going to walk through what to expect if you sue someone who's broke, what happens if you're being sued with no way to pay, and how courts handle these situations. And finally, how you can protect yourself, financially and legally. Let's dive in. What happens if you sue someone who has no money? Let's start with the most common scenario. You've been injured and you're suing the responsible party, but you find out they don't have the money to pay. What now? Well, the court doesn't base its decision on whether the defendant can afford to pay. If the court finds them liable, it will issue a judgment in your favor. That means that you have officially won your case. But, and this is key, collecting that money can be another battle entirely. Even if they're broke right now, there are legal tools to help you recover funds, including wage garnishment, where a portion of their future income is redirected to you, seizing personal assets like a vehicle or real estate, freezing bank accounts to collect whatever funds they may have available, liens on future property or income, which can be enforced over time. If they have insurance, that's often the best case scenario. Their homeowners or auto policy may cover your claim up to its limit. Bottom line, you can still pursue compensation, even if it takes time. What if you're the one being sued with no money? Now, let's flip that script. What if you're being sued and you can't afford to pay? It's a stressful place to be, and unfortunately, not uncommon. Even if you're broke, if the court rules against you, you may still be legally required to pay the damages. That can lead to wage garnishment, frozen bank accounts, and asset seizures. But it's not all doom and gloom. Some types of income, like disability benefits, are typically protected from garnishment, and in certain cases, bankruptcy may discharge some or all of the debt. It's critical to speak with an attorney and understand your rights. Many personal injury law firms only get paid if you win your case, which can make legal representation more accessible. How to collect money if the defendant has none. Let's go deeper into how plaintiffs can collect judgment when the defendant is financially strapped. Here are 6 potential methods. 1. Insurance coverage. In many cases, defendant's insurance pays the judgment, whether it's auto, homeowners, or business coverage. This is typically the fastest, cleanest path to compensation. 2. Wage garnishment. If the defendant has a job, the court can order a portion of their paycheck to go directly to you until the debt is paid. 3. Seizing personal assets. This includes vehicles, investment accounts, or even property. If they have something of value, the court can help you collect. 4. Freezing bank accounts. If they have funds in a checking or savings account, the court can freeze it and redirect the funds to you. 5. Future income. Even if you're unemployed now, your judgment remains valid. If they start working again, you may be able to collect later. 6. Business income. If the defendant owns a business, you might be able to collect through the company's profits, depending on how the business is legally structured. Key legal realities to know. Here are some important things to understand, regardless of which side of the lawsuit you're on. Ability to pay does not affect the verdict. The court's job is to determine liability and damages, not assess your financial status. No money? You may still win by default. If a defendant avoids court because they think they can't pay, they may lose automatically. This is called default judgment, and it gives the plaintiff full legal authority to pursue collection. Judgments can earn interest. Many states allow unpaid judgments to grow over time. That means if someone delays paying, they'll owe even more later. So whether you're trying to collect or concerned about being sued, avoiding court doesn't make the problem go away. Should you even sue someone with no money? Here's the million-dollar question. Literally, should you bother suing someone who has no money? Well, the answer is it depends. If the person has no current income, no assets, no insurance, your recovery options could be limited. But if they own property, have a job, or might inherit or earn money in the future, a judgment puts you in a strong legal position to collect later. An attorney can help you evaluate the case, search for hidden assets, or determine whether the defendant has insurance that might pay the claim. In many personal injury cases, this due diligence is handled for you by your legal team, so you're not chasing down someone who truly has nothing. What about small claims court? Let's say your claim is on the smaller side, maybe a few $1,000s. In that case, small claims court may be a faster and more affordable route. And here's how it works. 1. Gather evidence, medical bills, photos, witness statements, and other documentation. 2. Serve a demand letter. Give the defendant a chance to pay before court. 3. File the case. Present your evidence in court. 4. Pursue the judgment. If you win, start collecting efforts using legal methods. The process is simpler, but legal representation isn't allowed in small claims court, so preparation is key. How Stonewood Funding helps plaintiffs stay afloat. If you're the plaintiff and you're under financial pressure while waiting for your case to resolve, that's where Stonewood Funding can help. We provide non-recourse pre-settlement funding, which means there's no monthly payments, there's no credit checks, and if you lose your case, you don't repay the advance. It's not a loan. It's a cash advance based on the strength of your case. We work with your attorney, and if approved, you can receive funding in as little as 24 to 48 hours. It's a lifeline during the legal process, one that helps you stay financially stable without sacrificing your claim to a fair settlement. Apply now at stonewoodfunding.com or call us at 844-544-3863 to speak with a funding specialist.